urged that we engage with them in that fashion. The secretary of the committee will have to write to them, because we met them formally, to say, yes, we know there was this meeting, give us a short report so that when we meet the board, at least we know what happened yesterday. That's one issue that we are going to deal with. Second issue that I want to raise, I won't say it's an escalation, but issues of corruption currently are being dealt with. One of those issues, you know yourselves, that the Hawks and those agencies are dealing with, are issues related with state capture, including issues of Guptas. But what emerged over the weekend in Sunday papers was the issue of, because I must raise this one, it affects a lot of us, the issue of South African Express, because that airline is grounded. There is a person who was in Sunday Times who was given money or awarded the tender, but there was no delivery in terms of fuel. So there is that. So members from small towns like our own have to go via Johannesburg when traveling. Last night, those who are coming from my town, East London, they had to leave East London at 6, only to connect at 9:15 from Johannesburg. And then we arrived here after 11, meaning we had to be in our houses around 12. But the good thing about last night's flight, SAA from Johannesburg, in that flight, we were together with the President, Honorable His Excellency, Cyril Ramaphosa. He was flying with us, with his entourage. So there are those issues that are related to corruption that are emerging, that as government, we are slowly dealing with them. I was raising the issue that the content advisor is going to deal with of SABC because of the number of workers dismissed, about 26 of them recently, and those who were around 200 were affected by the medical aid fraud. So the reason why I'm raising this is because the committee is now involved. And the committee's view is that we don't need more people unemployed. We don't need to add, as both private and public employers, we don't need to add to what we have already. So we really need to assist in dealing with those matters as members dealt with them last time. Positives in terms of 100 days of our president. I'm sure you have read in papers, you have heard that the 100 days of President Ramaphosa has a lot of positives. There will be many people who will say there is nothing done. But I think most of us are saying the government is in the right direction. And I thought I must raise these issues, members, so that as communications portfolio committee, we talk about these things. Not necessarily in the boardroom here, but I think as we communicate, we need to raise these issues as people who are putting our shoulder behind the wheel in terms of correcting all these issues, whether they are related to unemployment and corruption and all of that. We are going to get a presentation from the content advisor on the summary, what we said, those many pages that unions submitted to us. We said they must package it according to particular headings or items. If it's issues related to governance, package those issues there. So that as this committee, when we deal with management and the board next week, at least we are clear as to where we are going. So members, that was by way of opening, and I thought it would be necessary that our communications as Parliament, we just need to check up our way of communication because we are a communicating portfolio committee. So we must be seen communicating. That's at the level of the portfolio committee, communicating. But I think we want to hear more political parties participating in this committee, speaking as political parties, so that we have all these views, not necessarily deviating from the decisions of the committee. Thank you very much, members. The only apology that we don't have is Honorable Bongo and Honorable Mbinda. Who's that? Mbinda, I'm told, he sent an SMS, and then Bongo. Mbinda is coming later because of the debate in the House. From Bongo, there is nothing. I'm sure the ANC is listening because it talks to the party where he comes from. Mr. Malika, will you, I don't think we need to reflect on what I was saying. I think let's just proceed. Icasa chair issue is that can we get the presentation?
Good morning, Honorable Chair, honorable members. Thank you. Today's presentation really will be on the summary of the submissions that were handed to the committee as per the request of the committee. Myself and the researcher will actually be co-presenting on this matter. Just to give a background, as you are all aware, in April of this year, the Portfolio Committee conducted an oversight to Johannesburg, specifically to look at particular entities, namely the MDDA and FPB, in relation to the maladministration there. But as part of the oversight, because of the correspondence that the chairperson's office has been receiving around the SABC matters, the committee had resolved to meet with the unions, trade unions that are active at the SABC. And there were 4 unions that were invited to that meeting, and that is the Media Workers Association of South Africa, MWASA, the Information Communications Technology Union, which is ICTU, EMFLA, my colleague will explain a bit further down the slides as to their connection with ICTU, the Communications Workers Union, and the Broadcasting, Electronic Media and Allied Workers Union, BEMAU. As a form of the resolution, of course, was that they should hand out written submissions to the committee, because we did have time constraints when we met with them. So, of course, many issues were not really thoroughly debated too. Hence, the committee resolved that they should hand in written submissions to the committee. As per that correspondence, only 3 unions out of the 4 actually made submissions. And that's the MWASA, EMFLA, which my colleague will talk to later in his presentation, and BEMAU. Just to give a bit of a context into the rationale really for looking into the matters of the union, I think the most recent activity of Parliament was that of the inquiry into the fitness of the board of the SABC. And throughout the findings and recommendations, what was consistent was the financial and the non-financial mismanagement, and that there was a problem in the organizational culture of the public broadcaster. But also highlighted through the inquiry process was that there seemed to be a lack of oversight on the part of Parliament in as far as the SABC was concerned. But also to mention that, you know, within the sector that the SABC operates in, it's quite a technical sector with lots of developments and of course highly literature intensive, and of course necessitates the committee to have a more intensive look or oversight into the entity. Of course, the proliferation of technologies always has an impact, as we know that the country is due to migrate to digital technologies, so that also has a bearing on how the public broadcaster is adapting to the change in technology. Another important factor is really the Broadcasting Act, which is really the founding document for broadcasting in South Africa. And of course, that in itself builds quite an extensive context in why Parliament plays such an important role in this public entity. The political environment also largely contributes because of the nature of the public broadcasting mandate and the recent political changes, or rather that we went through in the 2014-2015 financial years, the change in the ministries and so forth, also gives some context to the ongoings that are happening there. And least to say the funding issue, which has been raised in a couple of occasions, that as a public broadcaster, they only receive 2% of funding from government. And so that in itself pits them or puts them in a very precarious position, because most of the time they have to compete for content rights with companies such as MultiChoice, and without funding, we can't really expect them to give much on that. But I think that the reason for us to really interrogate the entire broadcasting value chain is really underpinned by the constitutional obligations, specifically the Bill of Rights, which most of the broadcasting issues of promoting diversity and unity and ensuring that the people of South Africa participate in the democratic processes of the country. I don't think that it should be seen as though the committee is getting involved in the daily operations of the SABC, and I think that's why I was giving the context, so that we are all aware that the interrogation of the unions, and or rather the engagement with the unions, should be seen in the broader holistic view of trying to pinpoint where the problems are in the entire broadcasting value chain, in as far as it relates to the public broadcasting mandate. I will hand over to, or before I hand over to my colleague, I just wanted to say that in terms of the submissions that were made, we were able to at least pull out about 5 themes. One is on the organizational rights for trade unions that do not have a majority, the filling of critical vacancies, understanding the mandate of the SABC, transparency, accountability, and inclusive communication, as well as long-term contracts for freelancers at the SABC. I'll hand over to the researcher for the presentation, and then I'll conclude at the end. Thanks.
Good morning, honorable members. Just to give an overview in line with the themes identified in the submissions to the committee. The first one being organizational rights for trade unions that do not have a majority. Both MWASA and EMFLA, which is the Electronic Media Freelancers Association, both the submissions contended that there was a need for the recognition of trade unions, even though it was not a majority union. Of importance was that one or more of the unions are granted permission to exercise acting jointly rights under Section 12. No, I'm reading from the summary document. The first theme is organizational rights for trade unions. Yes, Chair. I'm speaking to the presentation.
But where's the summary document?
No, it's submitted.
Which page?
I'm on the first page of the research document.
Oh, thanks, Chair. Yeah, I think what we are noticing is perhaps they could not page their submission. It's not numbered. And it could have been assisting, but however, it will be ideal if you are able to guide us through as to where now, because you could not number your presentation pages. Thanks, Chair.
Okay. Okay. Yes, Chair.
So tell us, you speak under which heading on this document?
Yes, Chair.
Under which one?
Now, I'm speaking to the first theme, organizational rights for trade unions that do not have a majority. It is the 8th slide. The slide is up on the projector as well. I'm speaking to the theme, reading from the document that was submitted.
So you are on this one, summary of issues raised.
Yes, Chair. And I'm speaking from, yes, Chair. And I'm speaking from sort of the narrative document, the document that was submitted. Okay. So both MWASA and EMFLA submissions contended there was a need for the recognition of a trade union, even though it was not a majority union. Of importance was that one or more of the unions are granted permission to exercise acting jointly rights under Section 12, 13, and 15 of the Basic Conditions of Employment Act. MWASA went to the extent of giving evidence that dated as far back as 2011 of how, under the direction of Hlaudi Motsoeneng, the SABC began deviating from the terms of agreement set out in the CCMA process and the framework agreement assented to by the SABC, CW, BEMAO, and MWASA. The deal was to undermine the GLG prerequisite reduction of 800 positioned, was fashioned with 2 unions and served as the base for the deleterious tenure of Motsoeneng. MWASA contends that it was openly excluded and that after months of official SABC public official SABC public relations program to malign MWASA, the physical threatening of its members, and to literally force them from abandoning their MWASA union membership. Mwasa was finally recognized on the 3rd of August 2011, dismissing 2 members of the union who worked in SABC payroll. Under the second theme, filling of critical vacancies at SABC, page 2. Yes, Chair.
No, I want you to work with us.
Okay.
To have a document that talks to that. Where are we based? Where do we base this right?
On the submissions, Chair. The submissions by the union.
Do they? What I'm trying to say, I mean, if we're discussing, if we're discussing with, and if we're preparing for a discussion with the board, where did they derive this? You say in their submissions, where are they basing this? Is there a document? We can say they base what they say. In other words, it says here, Mwasa was finally derecognized. Where is that recognition document that recognized Mwasa, who was now derecognized in 2011? Okay. Do we have that document?
No, Chair, they did not submit.
Do we have a document that talks to Al-Kam? I just want to be clear as the presentation is made. Is there any document that says unions that don't have the majority may be recognized by employers? Do we have that document?
No, sir, we don't have such a document. What the union submitted was its own presentation around the circumstances of their relations with the employer, and then also submitted a court judgment from the labor court, and
okay, all right.
Yes, as evidence
all right.
to support
no, that's fine.
their
Maybe
submission.
I'm disorganizing members. Teddy and
Comrade Chair, you are not disorganizing the meeting. Because that's my point as well.
Okay.
I expect him to make a presentation of the issues as raised by the unions.
Yes.
And also then come in. I agree you are a researcher.
Yes.
You must then be able to say, of what has been presented, looking at the various legislations that runs labor relations issues, all of that, this is supposed to be the situation. I think that's the point that Chair is saying. Because you are a researcher. You must go beyond what the unions presented on that particular day.
Okay.
I think that's exactly the point that the Chair is saying. You must then be able to assist the meeting and say, this is what they presented, but from our research point of view, this is supposed to be the situation.
Yeah, Chair, perhaps maybe in understanding on the organizational rights of trade unions as well, will this mean that Mwasa or that union stopped to exist or was discontinued by powers that be? Maybe I just wanted to understand as well. Okay, thanks.
I hope you understand where we're coming from. We want to understand you better because after the submissions of unions, they talk about their rights as minority unions. Where is that based in terms of employer-employee? In terms of Labor Relations Act, is that covered?
Okay.
Basic Conditions of Employment Act, all those things. So that we don't base ourselves only on what unions submitted. Went further and said, looking at the LRA, Basic Conditions of Employment Act, all of that. This is the situation. In terms of the de-recognition of Mwasa, there was this document that recognized them. And later they were de-recognized, and all of that. Those are the things that we're trying to get as you proceed presenting.
Okay, thanks, Chair. Just to maybe address some of the issues that the honorable members have raised. If you look at the next slide, that which Mbo will present, would then touch on the issues that members have raised with regards to Labor Relations Act, and then Mbo will also give a diagnostic overview and use the South African Post Office as a case study in relation to the issues that are being discussed. With regards to Mwasa being recognized or de-recognized, I can only present as far as what Mwasa has presented. I do not have access to documents where I'm privy to the recognition agreement between the SABC and the unions, and not just Mwasa only. Hence, I was saying that insofar as the submissions received, these are the issues that are raised by the unions. Mwasa has gone to the extent of submitting a court judgment in relation to the Labour Court, and also a communication between Mwasa and, the unions and the SABC on how the issue between the issue about the staff that was dismissed for the medical aid fraud. I'm not sure if I do justice to the issues that the members have raised.
No, thanks. I think let's allow him to present whatever he has prepared. Then we'll thereafter seek clarity and clarification. I think, Chief, you can just continue to a presentation as you brought it, then we'll interrogate it later.
Okay. Oh, that's fine. Okay. Go back and...
Thank you, Chair. On page 2 of the narrative document or the summary document, and on slide 8, the second bullet point, filling of critical vacancies. Amongst the 3 submissions, Mwasa was the only union to raise concern around filling of vacancies at executive management. The union noted with concern that as it stands, the SABC had only one substantive executive in the form of the COO, while the rest were acting over prolonged periods after rising to these positions through what it called a compromise system that was the subject of the ad hoc inquiry. It further noted that it was deeply concerning that several compromised individuals remained in office, presiding over what should amount to the undoing of their own interests. Mwasa further stated that the acting on higher grade policy of the SABC does not encourage that positions on fixed establishment and which are budgeted for may remain vacant for longer than 3 months, or that the acting on higher grade may continue on consecutive basis beyond 3 months. On the third bullet point, understanding the mandate, Mwasa was of the view, again, Mwasa was the only union that touched on this issue. Mwasa was of the view that it was of paramount importance that a full-scale analysis of the SABC is conducted as a follow-up to a similar study that was done by McKinsey & Co. and the ad hoc inquiry into the fitness of the SABC board. The purpose of such an analysis would be to gain further insight into understanding what is meant to cost the public mandate and how ring-fencing of such funding occurs when, as at the present moment, there is no proper appreciation of the aggregation of system failures that are designed to leak resources, and through strategically arranged offices throughout the value chain of the SABC operations. With regards to the third bullet point, still on slide 8 and still on page 2 of the summary document, transparency, accountability, and inclusive communication. all three submissions were clear that with regard to issues of accountability, transparency, and inclusive communications, there were issues with regard rather to accountability, transparency, and issues of communication, inclusive communication. While the above mentioned matters are not exclusively related to the issue on medical aid fraud, it is just one example where there has been such problems. The unions allege that the SABC has not adhered to its own code of conduct and has flouted labor legislation when dealing with the medical aid matters. The submissions do not delve into which areas of labor legislation that the SABC has flouted in this regard. In terms of the SABC's disciplinary procedure and code of conduct, disciplinary hearings must be conducted internally and by a panel of 3 SABC employees. The collective agreement and disciplinary procedure and code of conduct is then understood to be an agreement binding both parties. As such, the SABC was prohibited to then, in the absence of an agreement, to deviate from the disciplinary procedure and code of conduct and was compelled to strictly follow the disciplinary procedures. PEMAO then goes as far in stating that when it heard of the contemplated disciplinary action against its members in respect of the medical aid fraud, it had approached the SABC in an attempt to enter into negotiations with the SABC on how to deal with these particular issues. A meeting was conducted by the then acting COO, Hlaudi Motsweneng, and it was agreed that there will be a follow-up meeting by the SABC to decide on a way forward in respect of disciplinary hearings of members implicated. But despite this undertaking by the acting COO, the SABC proceeded to unilaterally appoint Tukiso, an external party with whom PEMAO had no agreement to chair the disciplinary hearings. The unions have submitted communication in this regard with regards to the agreement between the SABC and Tukiso. With regards to long-term contracts for freelancers, if EMFLA raised the following concerns with regards to the conditions of freelancers. At the SABC, black workers have no rights in the workplace, and it is in contravention of the legislation such as the Industrial Coalition Act of 1924, excluding African workers from the legal definition of employee. Freelancers are kept on a contract for years and have no rights to access the benefits of employees. Long-term contracts never translate to full-time employment below, and then they give a definition of what an employee is. Then they continue to further state that SABC is in contravention of the Labor Relations Act number 66 of 1995 as amended, and the Basic Conditions of Employment Act number 75 of 1997. And they request that SABC must clarify the actual nature of the employment relationship they have with the freelancers, since this cannot be defined by a mere label attached to relationships in the contract. I will then hand over to Mr. Maleka, Chair, and honorable members to just delve on, to do a deep dive on the other issues.
Thank you. Thank you, honorable members. Honorable Chair, just to reiterate what my colleague was saying. So what happened is we got submissions as per the request of the committee. And what he had just presented is a summary of the submissions. Now, this coming section, which I will deal with, is almost an analysis of the issues that emanate from that. But I have to outright say that we are not labor specialists. Neither am I, or neither is Mr. Dibeto. But of course, due to the nature of the job, we obviously have to delve into some of the issues in detail. For instance, the Labor Relations Act, which is also quite a technical document. But I do trust that we did some justice in terms of trying to extrapolate key issues that that we had reflected through the summaries that was presented. So firstly, I'll deal with the issue of the post office. And I'll delve more into that as to why I use the post office as a case study. I'll also do a diagnostic overview of the issues, and then delve a little bit into the issues in relation to the Labor Relations Act and what is transpiring at the SABC. And also, lastly, we'll talk to issues that we consider that the committee should actually consider as a way forward. I'm sure members will recall that during our oversight, one of the issues that the members had raised was the anomaly in relation to the proportion of employees versus the number of labor unions present at the SABC. To be exact, there's 4 unions, or there were, operating at the public broadcaster for only 4,000 employees. Now, if you contrast that to the South African Post Office, which has approximately 23,000 employees, they had a total of 3 unions. And as outlined in the Labor Relations Act, the 2 of the unions that were operating at this South African Post Office then decided to amalgamate, thereby making it only 2 unions within the broader Post Office. And as you can see, Honorable Chair and members, a staff of 23,000 is quite a lot, but they were able to consolidate and have 2 unions, which in my opinion, would seem served a better purpose in advocating for the workers. So it is indeed an anomaly that you'd have so many unions for only 4,000 employees at the SABC. And in fact, the amalgamation happened in 1st February 2018. And I think now they are called something else. I can't recall the name, Rodessa or something. The second issue really I wanted to talk to is the diagnosis really around the SABC. And to say that despite the legislative tools and regulations that promote an environment of consultation between the institution and its employees, and as you will see with the Bemau case, for instance, where the union claimed that the SABC acted without consultation in the process to appoint the head of the disciplinary hearing for the 25 members that were expelled. And that is totally unheard of, because the labor relations is quite clear in terms of the relations between the employer and the employees' organizations. So it's safe to say, honorable members, that the SABC is reflecting a post-trauma scenario. If you recall, coming from the era of Hlaudi Mtsweneng, the former COO, and the previous board of Professor Makuve, which really, worsened the situation of a problematic organizational culture, where there was numerous cases of intimidation, a huge presence of the state security agency, as well as purging of employees if they were seen not to be agreeing with what management wants. And of course, this has created quite a tense relation between the workers and management. For that matter, there seems to be little unity between the unions themselves, sometimes even amongst the workers themselves. So it's quite an anomalous situation, so to speak. And as you will know, that in some instances, as reported in the media, workers in some sections are not only unionized, but they are also not classified as employees. Again, highlighting a huge issue around outsourcing, which is a broader government issue. Safe to say also, based on the reports that were submitted, that there's clearly no laws that protect freelancers to be absorbed into the organization. And this is not the case for workers that come through agencies, because the Labor Relations Act is quite annotative when it comes to employers that come through agencies and that they can be absorbed into permanent structures of the organizations. Freelancers don't enjoy that kind of right, and nowhere are they protected. And I'll go a bit deeper into the freelance issue in as far as the Labor Relations Act is concerned. CW, for instance, I just want to make some examples of a precedent set by the unions so that it is not seen that they are all as innocent as they may have appeared before the committee. It's known now that CW was part of the campaign to support Mr. Mtswening during that era, and that some of the shop stewards were elevated to supervisory salary scales in tandem with the meteoric rise of Mr. Mtswening. And of course, there are several other employees who access promotions simply because at the time they shared support for the former Chief Operations Officer. So I think that, at least in my opinion, that this relations at SABC are actually an endemic reflection of the nature of the beast in South Africa in terms of the relations between the employer and the trade unions. And you know, the politicizing of the unions is also posing, to some degree, a problem, because that's why you end up not seeing what is supposed to be done in favor of the employees versus in favor of the employer or the mandate of the employer. I want to build a premise over and above the Bill of Rights, which is really what the sector is supposed to uphold. Now specifically looking into the issues around labor issues. Section 23 in brackets 2 of the Constitution is quite clear that every worker has a right to form and join a trade union, to participate in activities and programs of a trade union, and lastly to strike. The Labor Relations Act, in sum, really applies to all workers and employees and aims to advance economic development, social justice, labor, peace, and democracy of the workplace. The Labor Relations Act, like I said, applies to employees equally as the employers and the trade unions and organizations that they represent. But few departments are excluded from this, and that's the National Defense Force, the National Intelligence Agency, and the South African Secret Service. Section 213 of the Labor Relations Act defines an employee as any person, excluding an independent contractor, who works for another person of the state and who receives or is entitled to receive any remuneration. And as you can see, honorable members, that independent contractors, and I think the SABC has been using this clause quite prevalently to exclude the freelancers from participating in the industrial action or in benefiting the freelancers of the organization. Furthermore, the Labor Relations Act states that a trade union wishing to register must also be free from influence or control of an employer or employer's organization. And like I said before, the case of CW already sets the precedence that they've been in bed with the employer. So what would make them different now? These are the issues that we really need to get to the bottom of. In terms of disputes, the Labor Relations Act is quite clear also. So there's avenues for labor unions to exhaust should they feel that their issues are not attended to by the employer. As such, any party may refer in writing any disputes about the rights of trade unions to a statutory or bargaining council, the CCMA, or the Labor Court. And I think through Mr. Dibetso's presentation, you could tell that the unions, some of the unions claimed that they did exhaust the CCMA route with no really tangible positives coming out of that. So, honorable members, I think in closing, I thought that I would make a few considerations for members to consider. The first being that the submissions make clear allegations against individuals that were previously part of the SABC and some that are currently part of the organization. It is important that the committee shares the submissions with these individuals mentioned in promotion of fairness. So these are the individuals that the trade unions themselves single out. But over and above that, like I said, a lot of conspirators during the Mutsuning era, and as mentioned in the ad hoc committee report, ad hoc committee inquiry report, that all those who aided Mr. Mutsuneng should also be facing the might of the law. And I don't think, in as far as the committee, we have really exhausted that, although we know that there is a process that was begun to consult with the Speaker of Parliament in as far as ensuring that some of the individuals that were involved in the mismanagement of the SABC are held accountable. But obviously, more needs to be done. Furthermore, it's safe to say that some of the freelancers, and as we might all know, have been with the institution for over 20 years, 25 years, 30 years. And it absolutely makes no sense that the SABC would lose or sacrifice this institutional memory that they have, especially in the advent of the digital migration process, which will require such skills. So I'm not sure how what is their plan if they don't protect these freelancers, because all they know was to produce content for the SABC. And I think that strategically, the SABC has to see these people as a valuable asset to them. The challenge now is how do they ensure that the freelancers become part of the organization? A key impediment to this is the funding of the SABC, of course, because for it to compete with the likes of MultiChoice, who would gladly take this institutional memory to grow their own brand, the SABC really can't compete with the pockets of such organizations. It is our view also, honorable members, that perhaps further consultation with the Labour Portfolio Committee of Parliament would assist in view of trying to resolve challenges, labor relation challenges at the SABC, particularly with the issue around the freelancers. And another issue for the committee to consider is a consultation with various state organs, such as the Public Service Commission, the Treasurer, and the SSA, and the Public Protector, because all those somewhat have a direct bearing on how labor issues can be resolved at the SABC. And lastly, I think the committee has been on point in terms of holding the board accountable, and this has to be a consistent practice until such time that Parliament is satisfied that the SABC is returning to its former glory and issues around labor relations are being normalized. Thank you, Chair.
Thank you. That's the presentation, members. As agreed that we get the entire presentation and then engage after that. Hence, welcome, Honorable Mbinda. We did get your communication. Honorable Van Dijk.
Thank you for a very thorough presentation. With regards to this, the employees that has been dismissed from the SABC, I've concerns. My concern is they're not recognized as employees of the SABC, but as freelancers. So now when the unions take their issue, it says here in the presentation that if they've got problems or if there's labor relations like this issue now of the dismissal, then it should be taken to the CCMA or the labor, the court. But if they're not recognized as employees, what remedies there really then from that CCMA if they're not really recognized as proper employees? So will there then really be a remedy from that way if they go that way? So I really have concerns about this issue of the people that has been dismissed. And then I also agree with Mbo that it's really important that I'm not sure if this should be, this whole issue of the freelancers should be, the problem should be taken to the labor relations. But in a way, if people are there for 25 plus years, they're definitely contributing to the system. And it's true, digital migration, there will be a need for people that have the knowledge to assist with content development because there will be a huge shortage of that. So what is the problem within the SABC that they cannot, over these years, sort these problems out? We all are trying to see how we can operate to benefit workers. We want to bring in a minimum wage, etc. But we have this organization like the SABC, a public broadcaster, and we cannot help or assist to sort out the problems within that. Not that it's our, but in our oversight role, assist to sort out. And it cannot be that 26 people are just being dismissed. And yes, then I also want to ask in relation with that union, CWU, that apparently, and the cloudy relations, what happened in a case or a situation or scenario such as that? In future then, if they now, it's now in the open that they've, so what happens now within the SABC? How do they approach this how is it that going to be addressed? I'm just curious about that. Thank you, Chair.
Yeah, maybe the last point before coming to you. You know, most there is Mwasa, Pimau, ICTU, and what? And CWU. And all of them are competing in terms of membership there. So surely one will accuse the other. I'm not very sure that we must get into that. I'm not very sure that we must get into accusing Communication Workers Union on the basis of what they said. Otherwise, in my view, we'll miss the point. We'll be taking a particular position against a particular union. So I don't think we must get there. If there are issues, let's investigate those issues. As I say, there are many unions. One will talk about another. So I don't think we must get into that, even if it's in the submission. I don't think it's a point that we must escalate it to this level. But I understand your point, Honorable Van Dijk, because it's in the report and it's in the presentation. But I don't think we must get into that. Honorable Kaba.
Thanks, Chair. Chair, I think, I don't know if this would assist in guiding our understanding. I think we must acknowledge the fact that the presentation by the unions had been organized and given to us, and we were to meet the board, but the board is meeting with the unions, because it will be like perhaps we are engaging with ourselves, whereas questions of which we may need clarity on here are yet to be engaged in the next meeting. So perhaps we could escalate this presentation given here to our deeper analysis, wherein we ready ourselves for the next engagement. Because if we are engaged with ourselves here, I guess we may not be getting answers. So perhaps we must acknowledge it here And wherein we may have instructions to further sharpen it, we can do so. But for now, I think it is informing, it has armed us to be ready for the next engagement. Thanks, Chair.
I think Kaba is right, because indeed if we questions that or issues that we must raise are indeed issues that will assist us when we meet the board. I have my own issues that I will raise, but Honorable Mbinda.
Yeah, no, thanks, Chair. I think Honorable Kaba is correct. But at the same time, maybe the communication staff, what they can check, don't they have a recognition agreement? And in terms of the recognition agreement, obviously there will be thresholds, you see, on union, on recognizing trade unions. Even in terms of the Act, I think the last time I remember there were some thresholds. So those are the issues that I think even the board will have to familiarize themselves with. It's just to check, because sometimes when you have a lot of trade unions, it is obvious that it will lead to chaos. And you are correct, Chair, it is not for us to deal with that. Ours is just to look at what the law says and what the recognition agreement says regarding to that. And then if they are in breach in terms of recognizing each and every individual, then we need just to raise a bell for things like those. Thanks.
Sure. Tsedi?
Just two issues. I think it's correct that we might not necessarily have to go deeper into the issues, given the fact that we are just from our meeting with the unions. In that regard, it's correct that we might have to wait for the next meeting with the unions. But just two issues. One is with regard to unions individually coming to Parliament to raise whatever issues they're raising. It's an issue that we need to find a way of dealing with it. Because as much as they are fighting for their own space in that regard, but it becomes problematic for them individually from time to time come to Parliament, say these are the issues. Sometimes it defeats the purpose. The second one is the issue of workers who are not being unionized. It did not come up very, very sharply here from the report, and it's an issue that, as the committee, we're seriously concerned about it. It's an issue that we need to clearly flag out so that going to the next meeting, we'll then be able to raise it as a concern from our side without us encouraging workers to join Union A, but to encourage them to be unionized. But otherwise, I'm happy with the report. It's a true reflection of what happened.
Sure. Thanks, comrades. Do you want to go beyond this point? Because I was going to say, members, I don't think we must leave this thing too much of meeting the board. My view is that we need to program it as soon as possible, like next week. Otherwise, issues will become stale. But I think it will be important as we prepare for the next week meeting that we do get the recognition agreement, because we can get it. Looking at this thing, they say IMWASA was finally de-recognized. Surely they do have their original recognition as a union. Also, the recognition of other unions who are recognized, because MWASA is not. BIMAO and all of that. Let's get these recognition agreements, just to go through them and check what do they say. Two, if there is a in-house arrangement, you may be excused when your time comes, Honorable Kalako. If there is an in-house arrangement between the employer and the employee because of a union not meeting the threshold, let's have that. Because, but also we must have a document that talks to the threshold for recognizing the union. I know they were talking about 500 and all of that, but let's have that document. But in SABC, for them to recognize a union, they must have so much membership, but also something that says if the union is a minority, it doesn't meet the threshold. Does it mean that workers, Honorable Mbinda, cannot have a voice? Because I know you are from there, cannot have a voice. If there is that kind of an arrangement, let's have that so that we are able to engage the board. As far as I know, means staying within that environment, even if you are so many, but you cannot raise your issues. Honorable Mbina, maybe.
Yes, Honorable Chair, you are correct. Even if you are a minority, you do have a voice, but there's a threshold for majority unions that can negotiate substantive issues, which is your basic conditions, your
That's right.
even salaries and so forth. Yeah.
Let's get all those more, because we can talk to Mwasa, and then if they had a recognition, then they can give us. We can talk to Bimau, they can give us their own, so that we can be able to arm ourselves. Another thing they say, somewhere, a code of conduct. We're interested in that code of conduct. On transparency, accountability, and all of that. SABC has not adhered to its own code of conduct on your page 2. That's what it says, and has flouted labor relations or legislation when dealing with the medical aid matter. Let's get that, that code of conduct if we can. Because there are documents that can assist us as we prepare, much as we don't have time. The issues of filling of critical vacancies are issues that we have been dealing with as a committee with the department and SABC. All what I'm saying, let's get whatever document that can assist us to understand the organization better before we engage the board. Otherwise, thank you very much for the presentation, and I think it assists in terms of packaging the issues and what unions say. Again, we'll have to tread very carefully as we deal with the matter. Those who are those who are dismissed, unfortunately, they pin their hopes on this process, yet they have the unions. So those are the other things. And Nati, we said we'll assist them when we met them in Johannesburg. Whatever way we can assist them as a union, I mean, as a portfolio committee, let's do that. But documents will really arm us before we go to that meeting next week. Okay. Yes, yes.
Thank you, Honorable Chair. I just thought that I should make mention that the issue I had raised around CWU was just a mere example of the depth of the challenges at SABC. I can go on and make another example around Mwasa, which clearly said through their submission that some of their membership was being deliberately minused by the board. So on what basis was that? It's probably to keep them below the threshold. So what I was trying to show is that there's an anomaly between the unions themselves and the SABC and the unions. And at all times, it would seem to me that the SABC, at least in the past, was always using its leverage to pit the unions against each other, and they've not gone through that stage. And that's all I wanted to say, Chairperson. Thank you.
No, that's how employers deal with employees. That's what they do. I mean, without understanding that for them to have stability is to have a union. Because if there is no joy, no joy. If there is no joy, I'm not talking about you, Joy. If there is no joy between the employees and the employers, there will be instability. And then it will affect everything else in the organization. Thank you very much, members. Let's go to Icasa. We deliberately tabled this so that we can finalize it. Members, you'll recall that this matter, we were near finalization of it when we were tabling our report to the National Assembly for the removal of the Icasa chair. And then because of some technicalities or problems, it was referred back to the committee, and we are at that point now, where the matter was referred to us because there was a parallel process that was running, and there was a mention of an appeal on the process and all of that. So we agreed that from the office of the chair that we must amend the report so that we quickly take it back to the National Assembly and revert back to the issue that we decided upon of proposing or recommending in the National Assembly the suspension of the chair of Icasa by the minister, pending the so-called appeal. I'm saying so-called because I haven't seen. The last time I checked, it was an intention. Maybe you will advise us, because we'll allow the legal services to advise us on this one. And therefore, if there is that intention or there is that appeal, which I have not seen, then we'll have to recommend the suspension, which can only be actioned by the minister after we've recommended, after we've decided to recommend that the minister must do so. And there is a prepared report that I want legal services to talk to. Who's going to talk to it? Yeah. I don't know where it is, but if you can get a report, so that, because you will then be able to explain a number of things more than us in terms of that report. Members, that we thought we must just process this matter in that fashion, because it's now back to us as the committee. Before it is presented, are we on the same wavelength on it? The report was referred back to us now. We think that we must amend the report so that it talks about suspension. The original report was talking about removal. Savannah? Okay. Over to you, ma'am. Legal services.
Thank you, Chair. Chair, as you correctly point out, the report was referred back to the committee for reconsideration. The original report called for the immediate removal of the chairperson of Icasa. In terms of the Icasa Act, another option available to Parliament would be that when Parliament starts its removal process, that Parliament can request in terms of Section 8.3c that the Minister suspend the chairperson, and that's upon the request of the National Assembly after the start of the proceedings. The proceedings will then wait on one of two things to happen. Firstly, to see whether leave to appeal is granted, because of course you cannot appeal a criminal conviction unless leave to appeal is granted. We have not received clarity on whether that leave to appeal has indeed been granted. We tried to make contact with the lawyers for the chairperson to no avail. So at this stage, we're not sure whether the sentencing has happened or not, but the leave to appeal will only occur once that sentencing takes place. If leave to appeal is granted, the committee can then await the outcome of that appeal process in the higher court. If the conviction is then confirmed in the higher court, the committee can proceed with the removal as originally agreed to. If the conviction is set aside, then of course I presume that the committee will take a decision not to proceed with the removal because there will be no basis then in law. So in terms of the report is identical to the previous report that served before the committee, with the only exception being the last paragraph that reflected the resolution, which was originally for removal. That's now been reworded to read as follows. The committee accordingly resolves that the Minister of Communications must suspend Mr. Moshilalocha as a councillor and council chairperson of Icasa in terms of Section 8.3b of the Icasa Act until such time as the National Assembly finalises the removal process. And that's a decision to now be taken, Chair, where the members are in agreement with that amendment to the report. Thank you.
Don't you want to go back to... Okay, that's the part that we need to deal with. Because if you recall, there were, from the lawyers of Mr. Moshilalocha, there was an issue that they raised as a precautionary suspension. Just that I don't have it now.
Yes.
Do you remember that?
Yes, Chair.
part?
As
Okay.
part of the submission made by Mr. Moshilalocha, he asked for a suspension pending the outcome of the appeal process. So he indicated his willingness to step down in the interim whilst the committee finalises the process, but provided that we await the outcome of the appeal. When the matter served previously, there were attempts to interdict Parliament because of the parallel process that was taking place at the same time. And eventually we reached an agreement with Mr. Moshilalocha's attorneys that if we're going to put this back onto the order paper in the National Assembly, that we would give them 48 hours notice. But of course the intention then was if we were intending to put it back for purposes of removal. This is slightly different now because it's suspension, which he has indicated that he would be willing to accede to.
That's the, in the main, that's what we need to go back to. And I hope this can be done before Parliament rises, so that we just deal with this before the 18th of, before the 15th of June. But the proposal is that, honourable members, that we take the approach of taking this matter to the National Assembly for suspension by the Minister of Mr. Moshilalocha. Honourable Seti.
Chair, I concur with the proposer because in my view, it also works in his best interest so that even in the near future, if there are people who might want to challenge some of the decisions that have been taken while you're still chairing the committee, that might not create unnecessary problems. So all I'm saying is that I second the proposal which says let's take the matter to the assembly for a suspension to be processed while we are waiting for all these other legal appeal processes to be concluded in that regard.
This is the last sitting of, before we rise, today is the last sitting. Honorable Said is proposing that we we recommend to Parliament that the Minister suspends the chair of Icasa, Mr. Mhlaluka. And that goes with pay, with full pay. But anyway, we may not say that in the report. We are just recommending suspension.
Chair, the Act is silent on the issue of pay. It's a generally accepted principle in terms of labour law that when an employee is suspended, it is with full pay unless an agreement reflects otherwise. So the department will have to advise in terms of what the arrangements with him are.
Yeah, that's the proposal that we table to Parliament, our recommendation to suspend Mr. Mhlaluka. Honourable Van Dijk.
Chair, I also agree with the fact that he must be, I agree with the proposal, but the matter of the fact is this person was...
Are you seconding the
Yes, but
proposal?
I just want to, from my side, this person is now going to be suspended on because he cannot be continue in a position of trust. But he was convicted of fraud, so why must the taxpayers continue to pay? So that's something that we must really, I do agree that he must be, and he should have never been appointed in the first place because we knew that when we did the interviews that there was a question marks. So from my side, I would also then suggest that in future when we do our screening that we make sure that the candidates that go forward, that we don't have this problem. Thank you, Chair.
Don't go back to the earlier discussion, because if you are seconding what he's proposing, so he never said with pay. He said the proposal is that the minister must suspend the chair of Icasa from office. And it's not us suspending, it's the department, it's the minister. So we can't get into others. The legal services was clear to say it's not in the law that we must get into that. It's just that when now you are seconding him, but you're saying without pay. Members? Kaba?
Okay, thanks, Chair. Chair, I'm raising to second the earlier proposal. I think clearly outlined with pay. I think it also responds to our your earlier opening remarks of the meeting around the issue of maybe corruption and concerns that we may be having in the country, also acting in the public interest that we're in as government, we then realizes problems which may emanate to that angle, we then act. I think I'm raising to second him. Yeah.
Honorable Mbin?
Chair, no, I also wanted to second as it is. Otherwise, just to explain this issue of pay, what they are saying is that they will consult. I mean, it is normal that you suspend with pay. But because this is a chair, not a full-time employee, and obviously he or she will not be providing some services in terms of attending meetings. I mean, if it's suspension, they understand what it means. It means he will not get paid. But you see, let's just leave it like that, because nobody is saying it will be with pay. You see, but there will be consultation. When it is there is consultation, it is he must be suspended with pay. It will be with pay. If it's not, it's not. For us, really, let's leave it for now like that. Yeah, we would like people to be paid, but I mean, if the law says it says.
The councillors, that's the difference, members. The councillors they go to work every day. They don't go per a meeting. I think all of us have a sense that if you're wrong, if you do something wrong to the taxpayers, it's wrong. I mean, they can't pay you. But I'm not sure if you want to further explain this, because ours is to just say she must suspend. I'm not sure if you will come after Honorable Bongo. I'm not sure if you can go beyond and say without pay. Bongo?
Yeah, thank you, Chair. I think I agree with what the President is saying. Usually, if you're in a board and you are being paid as per the meetings that you attend. So, if you are not attending the meetings, it goes without saying that you will not be paid. Now, with councillors, if he's suspended, it means he's not going to go to work. And if you're not going to work, I wonder if you're not going to work, can you really demand payment if you're not going to work? But let's just not be emotional about it or be subjective. Let them follow the law to the letter. All we can say is that suspend, and then the practice will then kick off in terms of what the law says, what are the precedents that in the past. But it suffices for the committee just to say we want the minister to suspend, then that's it. Then they will look at the other issues that relate to the legalities around those suspensions. But I don't think we can pay somebody who's not coming to work, because if you're not coming to work, how can you be paid? But let's do what we are expected to do ourselves as the committee. Thank you, Chair.
No, that's fine. I think. Do you want to further explain because generally we say, let's say minister must suspend. That's our recommendation. Do you want to further clarify the fears that we have?
Chair, the Act only speaks to suspension. It doesn't speak to the issue of pay or without pay. The difficulty in this type of situation is that in many senses the person may be like an employee, but the appointing body here is Parliament acting together with the minister. So we're transversing labour law with an element of administrative law and the role of the legislature. And perhaps in future we must just be more aware when drafting legislation that these sorts of things are clear, because at the moment the only realm that we can turn to give us guidance would be labour law. And in labour law, suspension is considered an extremely serious and harsh step to take. And the courts are clear that where you can steer away from suspension, where it's unnecessary, so where there isn't a risk to the employer to have that person continue, then you shouldn't suspend. Our difference here is that the Act is clear that we may suspend, and the Act is also clear that these offences are extremely serious because they would have disqualified a person from being appointed to the post originally. It was one of the disqualifying criteria, and it's one of the issues to consider for removal. So certainly there's scope for these things to to be tested further, but the ministry would be in the best position to advise in terms of what the payment arrangements are, whether there was an employment agreement entered into between the chairperson and the department, and how they've dealt with other issues. I'm not sure whether he serves in a full-time capacity, because in some of these entities, the chairperson will be full-time and the rest of the members would be part-time, or whether he's paid on a meeting basis. But I see the committee secretaries indicating that he is there full-time. So I suspect he will be treated as an employee then.
No, I think Honorable Bongo was correct. I mean, the board, if it's the board, you are paid per meetings that you attend. But these are councillors, they go to work every day. They are full-time for the rest of their contract. So let us take this to the House, recommendation to suspend, and let the minister deal with other issues. Agreed? Okay. Members, can we, there is, I mean, without reading the report, there is something that it's seconded, it's proposed and seconded, the last part. The last part, it says the committee accordingly resolves that the minister, for record purposes, the committee accordingly resolved that the Minister of Communication must suspend Mr. Mhlalocha as a councillor and council chairperson of Icasa in terms of Section 8(3)(b) of the Icasa Act until such time as the National Assembly finalizes the removal process. That's what you were seconding as the committee. In Tsedi proposing and Van Dijk seconding. You didn't? Okay. Let's agree that Kaba seconded. And then you can argue your point when you go there on the podium. Okay, members, let's go to MDDA now, and that will be our last point. Let's go to MDDA. And the reason why I don't know what is this. We have 4 vacancies. I mean, in simple terms, we have 4 vacancies in MDDA. That we are responsible for, because we recommended those we recommended last year, and some of them resigned, and others' term ended. So now we have Dr. Mbava and Martina Delactonia as councillors we are responsible for as Parliament. It leaves us with 4 vacancies. And a letter from the Minister of Communication, per procedure, went to the Speaker's office to say, here are the vacancies that we have, and therefore it's now our responsibility to take the process forward. And the process forward is to advertise for those 4, and then when we come back, or whatever time we agree upon, we come back, interview for a day, and then go back to our constituencies. So the agreement that we seek to have in this committee is that should we go ahead with advertisement, and then give us also, as a chair, a mandate when things are done, communicate with you to come back, if possible, to interview for a day and then go back. Honorable Bongo?
Yes, we agree, Chair, with what you are proposing. Actually, it's long overdue. It's a process that we must move with the speed of a mirage. Otherwise, you must have had when we're at oversight. Part of the problems they are caused by these vacancies. So I just want to urge that we move with the speed of a mirage in terms of dealing with the process. If needs be, when we're home, you can call us back to do whatever process. Thank you, Chair.
Very much. We agree to advertise, and then we'll take it from there. Are we not done with them today? We are done. I'm sure you know that SABC is already out. It was on the other week, Sunday papers, not this Sunday, the other Sunday. They were out already for the 3 vacancies, and now we are going to advertise MDDA. Maybe we can deal with them maybe over 2 days when we decide. So that we deal with MDDA, and then after that, with SABC, and then after that, MDDA. That's agreed. Now the last item will be minutes. I don't know how many minutes are we going to deal with. Let's take another 20 minutes just to deal with them, 15 to 20 minutes, just to, yes we do. Mangeti. Members, do you have minutes? Are minutes circulated? So, do we have minutes? Speak so for yourself, Club.
Yes, Chair, they were emailed. I can open them now.
You were busy in those meetings of Telkom.
No, if it was Tuesday, I was there. Was it Tuesday?
But you don't have even an apology.
I
don't see an apology.
No, a problem here, it's not even said that you attended another meeting.
I see. I thought the Secretariat will assist in that regard, but as far as I remember, I was part of that meeting.
Page 4. Says when I have met.
I'm moving, Chair, for the adoption of the minutes.
Page 5 and page 6, those are minutes of the 20th February. Any mover? Honorable Van Dijk, seconded. Sedi?
I'm seconding, Chair.
Okay, minutes of the, 27th of February, page 1. What's going on there? Oh, kabam. Page 2, okay. On page 1. Is it? Where is okay. Page 1. Page 2, page 3. Any mover? Thank you very much. Machoba moves. Van Dijk. It's only you and Machoba. The what? They were not in the meeting. Are you seconding the minutes? Say that loud. Minutes of?
I'll check in.
Of the 27th February 2018. And thank you very much, members. That's where we end. Other minutes that we have will have to be processed properly before they come here. Members, that's the end of our meeting. And the meeting is adjourned. Very progressive. Thank you so much, members. But also, we must thank the leadership of Parliament to give us this time, the chair of the committees and all the political people who approve our applications. we may now go back to the House. Thank you very much. The meeting is adjourned.